Good afternoon, everybody, and welcome to Let's Talk. The topic for today's webinar is wills and trusts, and you will be hearing from Marcus O'Toole-Gello, who is an attorney here at Genzer Dubau, Genzer & Kona. He's going to talk to you more about the intricate details of wills and of trust planning. Marcus, I'm going to hand it over to you.
Good afternoon, everyone. I'm Marcus. I'm going to go over the various aspects of wills and trust in detail. So let's get right to it. At its base, a will is a document that says, okay, when I pass away, here is how I would like my assets distributed. But it involves a lot more than that, depending on your family situation, depending on your assets. So it's a good idea to kind of understand what you can and can't do with a will and what you should focus on. So one thing it does is it appoints people to be in charge of your estate and your financial affairs. That person's called an executor. And we'll get into greater detail on that in a moment. But another important thing that especially people with younger children think about is a guardian for minor children. So in addition to planning what happens to your assets when you pass away, if you have minor children, it's essential to think about who would they stay with and who would take care of them if something happened to you or you and your spouse. This is someone that is not just someone that may or may not be good with money, because you can put someone else in charge of the money. You want someone who's going to show the child love and affection, take them to school, be at their graduation, be involved in their lives more than just, making sure that they have enough clothes and food. So that can often create some uncertainty as to, okay, is it going to be your sister or my sister or whomever? But it's really important to pick someone or someone's, you can have two people, and some backups, because if something does happen, you don't want to leave it up to chance and to who's going to step forward. You should also really speak with those people and make sure that, first off, they would agree to do it, but kind of have a discussion about, what would happen, how would it work out, and a lot of it's going to depend on the age of your children. So, whether you have $1 in assets or $1 billion, a guardian for minor children is an essential part of everyone's will, who has children. So what happens if you don't have a will? There are default rules in New York about what happens to your assets when you pass away. If you have a spouse and children, the spouse gets $50,000 plus half, and the balance goes to the children equally, regardless of their age. It's also, if they're minors, it would only be held until they're age 18, then they get it all to do whatever they will with it. That's usually not what people want, whether they would prefer it all to go to their spouse, or if they have young children, age 18 is a little, suspect. Not everybody is quite responsible at that age. So a will allows you to have a more appropriate plan for your particular situation. If you didn't have a spouse or children, it would go to parents, and then further up and down the chain if your surviving relatives are more remote. So these are just the default provisions. It's called intestacy, but they're definitely not recommended because it can leave a lot up to chance. And it also doesn't let you select, who's going to be in charge of your estate, and again, who would be minors for guardian for minor children. So it's always a good idea to have a will regardless of your age. So let's get back to one of the things we talked about before, which was an executor. This is a person that you designate in your will to be in charge of your estate. Their first duty is to probate your will. So what is that? Probate is the process by which the will is submitted to a judge. In New York, it's called the surrogate's court. There's one for each county. And the judge would say, okay, this looks like a valid will. You've given notice to all of the appropriate heirs, and you are the named executor. I'm appointing you as executor, and I've created this estate. Then once the court, has probated the will, the executor you selected can collect your assets, consolidate bank accounts. If you have a house, maybe they'll sell it depending on if somebody wants it. They're responsible for paying your valid debts. That would be, medical expenses and mortgages if they're going to sell a house and anything else like that, as well as the expenses in administering the estate. So, when, depending on the complexity of your estate, they would hire a lawyer, an accountant, an appraiser, other professionals to help, an investment advisor as well. So they're allowed to pay appropriate expenses. One of the other core duties is obviously filing tax returns. So your tax return, the estate's tax returns, and paying appropriate taxes that are due. Once all of that's completed, they can distribute your assets the way you directed in your will, and can account to your beneficiaries, basically saying, okay, here's the money I collected, here's what I've spent it on, and here's how it's being distributed. And they'll have an opportunity to review it and make sure that they're okay with everything. An executor is someone that has a fiduciary duty to the beneficiaries. It's not their money, even if they're a beneficiary, they're also managing it for other people. So they have high levels of responsibilities. So you would want to pick someone that has a general idea about money and finances. They don't have to be an expert, because they can, hire investment advisors, for instance, so they don't go around picking stocks for you. But someone who's got a good head on their shoulders, can manage money, and knows what a tax return looks like, things like that. Most of the time it's a relative, one of your heirs or your spouse or something like that. Sometimes if you don't have a spouse or you have very young children, it could be, a brother, a cousin, a nephew, something like that. So it's important to think about that, to make sure you have someone in place to take care of those things. So in the will, you have an opportunity to leave an inheritance to pretty much whoever you want. But certain people may not be ready to just get a check, or it may not be in their best interest. So there's options in your will to set up trusts. So what's a trust? A trust is a receptacle to hold assets on behalf of someone else. So, a trustee who's in charge of those assets would manage it on behalf of a beneficiary. The trustee doesn't, own the assets. It's not for themselves, but it's for your child or your other heir. They're watching over the money for them, and investing it on their behalf and making distributions as necessary. And a trust can really help someone who, for various reasons, which we'll get into, shouldn't just have a check written to them for X dollars. And so there's a couple of common reasons why you would want a trust for your beneficiaries and not just outright, as we say. If you have a child or other beneficiary who's disabled, whether they got into an accident or there was a developmental disability, and they're on some sort of government benefit that is dependent on them not having a certain amount of assets, or even if not, if they're just a person who needs someone to watch over the money for them because they couldn't, you would want a trust for them. And if they're on benefits, there's a particular type of trust called a supplemental needs trust or a special needs trust, which we'll get into in a second, which can help with those benefits. But even if they're not on benefits, you'd want to protect them, make sure that the money is being spent wisely, managed, and that it's going to be there for them, when they need it. Other situations where you may want to trust for beneficiaries is you have a child or heir who, having marital issues, and there could be a divorce. There's a bankruptcy. Other personal crisis, substance abuse. There's they have a lot of debts. They have tax problems, or they're just not very good with money. They're spendthrift. You can have somebody in charge of the money and could provide for them, but they wouldn't have direct control and kind of protect them from themselves. Make sure it's really separate and that the inheritance isn't all blown on whatever personal issues they're having at the moment. Also, as we discussed before with minor children, if you did nothing, they would get their inheritance when they're 18. It's usually recommended that at the minimum in your will, you have it held for them until age 25. At that point, they've maybe gone to college, they've had some jobs, they a little bit more responsible with money at 25 than 18. So, even if, it's not something you need to protect them for their lifetime, it's a good idea to put it in a trust at least until age 25. That's kind of the minimum we recommend. So how does the trust work on a day-to-day basis? Well, the trustee, manages the money for the beneficiary, but that doesn't mean they can't use it for them. They could spend their money on care, they're getting married, they need a car, they're going to school, for tuition, for room and board, for their rent, for even their basic necessities. So you can set up in your will how much discretion you want to give your trustee, but they can really provide for them. They don't have to give the money directly to the person. They can pay, write the check to the school directly or write the check to the landlord to make sure that the money is being used wisely. When you're setting up a trust in your will, you could say, okay, it needs to be for their lifetime. This is common with someone who's disabled because, and especially with developmental disabilities, they're not going to recover most likely, so you want to make sure it's there for their life. If it's an age thing, you can set a specific age. It could be 25, 30, 40, whatever. Or you could just say specify for a number of years. And I just want them to get it gradually, so they can get used to money. Okay, I'll give them a piece after 5 years and the rest after 10 years, something like that. So a trust is a flexible tool that if you plan in advance for your inheritance to your beneficiaries, you can protect them from themselves and make sure the inheritance is used in a way that you would like for their benefit over the long term. And just like with an executor or a guardian, it's really important to select a trustee who's responsible because, again, they're going to be managing assets, filing tax returns, making decisions on what money is appropriate to spend. So you'd want to pick someone that's responsible. If there's a substantial enough money and you don't have someone like that, some banks and other financial institutions could act as trustee for you as someone that's, or an institution that's independent. So I briefly mentioned before supplemental needs trusts, which are for disabled persons who are on government benefits that are dependent on, the amount of assets. Like certain benefit programs say, okay, you can't have more than $2,000 in the bank, otherwise you're not eligible for these benefits. So you would want to leave them an inheritance, but you wouldn't want to compromise that because then, you would be spending money on something that their benefits could cover. So you would set up a supplemental needs trust. And there's two types. So a first party supplemental needs trust is the one that the disabled person sets up themselves with their own money. A common way of that happening is someone in an accident and they get a personal injury settlement and they're going to be on benefits because they're going to have long-term medical costs. So they can set up a trust with their own money and put it in there, and then it's not counted toward those, maximum asset limits for benefits. Since it's their own money, though, they're required to say, okay, when I pass away, if there's any money left in this trust, I have to pay the government back for any benefits they expended because it started with the disabled person's money. However, there's a different type called the third-party supplemental needs trust, where if it's set up with someone else's assets, whether it's an inheritance or a gift, there's no payback provision. So if there's any money left when the disabled person passes away, it can go to whoever the person who gave the gift or set up the inheritance wants it to, other relatives, heirs, etc. You're not required to give it back to the government. So it makes a big difference as to which kind or where the money comes from. But it's a really strong tool that's been around for a number of years that helps people, they can still keep their benefits, but there's money available to pay for other things to make their lives better. Because in a lot of cases, benefits programs, they pay for the minimum, health insurance and a small amount for housing. It's not going to make their lives maybe as have a higher quality of life as you would like. So by leaving them an inheritance like this in a supplemental needs trust, you can provide for that. So they can go on vacations and live in a nicer place and, enjoy themselves a little bit more. So that's definitely available. So it's important to plan ahead of time through your will, through the use of trust, to make sure that if something happens to you, you have the right people in charge, your assets are distributed the way you want it to be, and that your heirs and beneficiaries are protected, and that the inheritance you may leave them is going to be available for them for the long run. So, we talked about trust for other people, but trust can be used for the person whose money it is in the first place. A common, trust that we see in our practice is related to Medicaid planning. And we've had some seminars on this before, but remember that, for someone who, as they get older, and if they get ill and need long-term medical care, such as home health care aides or a nursing home, having Medicaid, trying to get Medicaid to pay for those things, there are maximum, eligibility rules saying you have to have less than a certain number of assets. So, if you plan in advance, you can shield your assets so they're not counted as part of those eligibility requirements, and Medicaid benefits would be available, and you won't have to spend everything you've built up for your entire life if, God forbid, you get sick and need a nursing home. So by setting up a trust ahead of time, you can shield your assets, avoid having to spend them on your care until you be eligible, and hopefully they're available for you, and in large part, so you could pass it down to your heirs and your beneficiaries. In Medicaid planning, we see a lot of people say, okay, well, I don't really want to set up a trust. Why should I do that? I'll just give my assets to my children. They'll take care of me. There's a few reasons why that's usually not a good idea. First off, once you give it to someone, if you just transfer your house to your kids, or give them all of your assets, your cash, well, you no longer have control over that. You may trust them now, but what if they have, like we were discussing before, a personal crisis, marital issues, a bankruptcy, creditors of their own? You could put that money and your house at risk. There's no guarantee they're going to use it for you, and that they don't have something maybe they're not telling you, or that circumstances may change in the future. If you're doing planning when you're 70 and you live till you're 90, who knows what can happen in those intervening 20 years. And if, God forbid, that child passed away before you and it just was in their name, it could go to their spouse or their children or someone else, and you may not get it back if you needed it for something. And again, if it was in their name, they would have to pay certain taxes on it instead of you paying for it. So it's usually not a good idea. So a trust is going to be preferable in almost all cases. Again, a trust is going to be a receptacle to hold your assets for Medicaid planning purposes. In order for it to qualify, it must be irrevocable, meaning you can't by yourself go take everything back. You can't be a trustee. Most people select their children or siblings or nieces and nephews, someone that they feel comfortable with for a lot of the same reasons as before, to be in charge of the assets. And you could put just about anything you want in it. Most commonly, you put a house in there and maybe some cash or a small investment, portfolio, maybe a non-qualified annuity. But it can hold any type of asset that a person can, with the exception of like retirement assets, like an IRA. You wouldn't put that in the trust. Like I said before, it's very common that people put their houses in the trust. It's kind of the least friction way because it just kind of sits there in the trust. And when you do put a house in the trust, You retain a life estate, meaning you can live there as long as you want. Nobody can kick you out without your consent. You retain all your property tax exemptions, your STAR, your enhanced STAR, your veteran exemptions, all of that. And you still pay all the expenses, utilities, upkeep, repairs, etc. So you're really not going to notice that it's in a trust. Day to day, it remains the same. You can sell the house in the trust. That requires, the trustees to kind of cooperate with you. But you can sell it. The money would stay in there. You could buy something else. The trust would still own the new one. And you're still keeping it into a trust, so you're not triggering, restarting the 5-year look-back period, which we'll get to in a second. And again, you as whoever sets up the trust is always going to have the right to live in whatever house is owned by it until you no longer want to. If you put in assets that aren't real estate, say a bank account or investment account, you can still get the income generated. Say you put bonds, a bond portfolio in there, all the interest income can still come back to you. You just can't go in there and sell it and take the cash out yourself. But we tend to build in some flexibility, so the most that Medicaid lets us do. So the trustees can distribute money out to the children if they think it's important, and then the children can use the money to pay for things for you. So the reason why you do transfers ahead of time is for the 5-year look-back period if someone needed nursing home Medicaid. The trust is just a better way of starting that 5-year look-back period rather than just giving them the assets. But we build the trust to be very flexible, meaning that, again, the children can have access to it as trustees if they need it earlier and need to pay for, a roof for an assisted living facility or whatnot. The flexibility is important because you're talking about 5 years or more, circumstances can change and you don't want to be completely locked in, to exactly not having any access, but you can't make the access too free because Medicaid rules don't allow it. So it's a balance, and we make it as flexible as you're allowed to. So when you pass away, similar to a will, the trust can describe, what happens to the assets that are in the trust. And again, I'd refer back to those things we were talking about with a will. You can create further trusts for the beneficiaries. You can pick who's going to get it. Just because you set up a trust doesn't mean you can't change the beneficiaries. By signing a new will, you can direct what happens to the trust assets. So, you still maintain that level of control, and the same options for, what happens to your assets on death in a will, we can do with this particular type of trust. Again, the benefit of doing the Medicaid Asset Protection Trust is to shield the assets if you needed care in the future, but there's a 5-year look-back period. So if you make transfers, you're not eligible for Medicaid in the next 5 years. But 5 years after that, anything that you would put in the trust there is not counted at all. And you can shield everything you put in there from having to be spent on your medical care. You'll be able to pass it on to your heirs, whether that's your house, your bank accounts. That can be hundreds and hundreds of thousands of dollars that you don't have to spend on a nursing home. These benefits are available, but in order to maximize those benefits, you need to plan ahead. Not everybody's going to make the 5 years, but you want to try. So the earlier you get to it, the better. So that's one type of trust you use for Medicaid planning in advance. Another type of trust that we run into a lot, or that we do, is more related to a particular type of Medicaid called home care. When someone stays at home and they have healthcare aides to provide for their daily needs for cooking and cleaning and bathing. Again, there's eligibility requirements, which, the irrevocable trust we talked about before can help shield your assets. But the next type of trust we're talking about is more concerned with income, okay? So the irrevocable trust shields your assets, but once you apply for Medicaid, you have to worry about, okay, well, I have a pension, I've got Social Security, I've got all these sources of income. Well, how can I protect that? If you're on nursing home care, this particular trust we're talking about doesn't apply, but if you're on home care, it does, because there's different requirements. So this type of trust, it's going to call the pooled income trust, you wouldn't set up ahead of time, but when you actually apply for home care Medicaid, you can do it at that point. Because if you're on home care Medicaid, you're only allowed to keep $800 plus in income each month, and ostensibly you're supposed to spend the rest on your own care. And for people living at home, that's usually not enough to maintain the house and all of your ancillary expenses. $800 is not very much. So what we do for the pooled income trust is help protect the rest of that. So a pooled income trust is a type of special needs trust. We talked about other types before. It's managed by not-for-profit charitable organizations. There's a great number of them who do that we work with. And the way it works is each month you contribute your excess income to the trust and submit bills to the not-for-profit, and they will use your funds to pay for your bills. If you didn't do this, it's called excess income. When you get a Medicaid approval, they say, okay, well, here's how much money, here's how much income you have over the maximum. You need to contribute it toward your care. You would normally have to spend that. That's called a spend down. You have to pay, and then Medicaid pays for the rest, right? After, if your excess income is $500 and your monthly medical needs are $4,000, you give $500 and Medicaid pays the other $3,500. But we'd like to protect that extra $500. So how do we do that? We deposit the excess each month into the pooled income trust, right? And then, again, you submit a bill with an authorization, and they would pay for mortgages, rent, utilities, clothing, food. They'll even pay for credit cards if it's in the applicant's name, but any kind of living expense or bill in that person's name. That could be a substantial amount. I mean, if you're living in a home on Long Island, it costs a lot to maintain. Even if you don't have a mortgage, you have real estate taxes, you have utilities, you have homeowners insurance, you have repairs. These things, are more than $800 a month for a lot of circumstances. So the trust lets you shield that extra income, and so you can use it for your own needs. And anything that's left over, the charitable organization keeps at the end when you pass away to use for its charitable purpose. So it's kind of a win-win there. And again, this would only apply for a particular type of Medicaid for home care, and it's only applying for income. So there's, hundreds of types of trusts out there. Today, I went over a couple that are, really related to elder care planning that we see a lot. Trusts for beneficiaries, supplemental needs trusts, irrevocable trusts, and pooled income trusts. Those are very common. We see them all the time, and they're really tools to help in planning for yourself, for your heirs, for medical expenses, etc. So there's a lot of options out there for planning in advance. So that's my presentation today, and I'll leave it back to Melissa.
Thank you, Marcus. We really appreciate the information. As you know, this webinar series is part of our TAWC program, Tools and Advice for Working Caregivers. We often see that working elder caregivers need information on resources and education about what to do if they're caring for an aging loved one. We want to help keep them present and productive at work and make sure they have the information that they need to be able to do that and ensure that their loved one is being cared for. We have coming up an executive breakfast to learn more about TAWC at our offices at 225 Broad Hollow in Melville. And that executive breakfast is on March 7th at 8 a.m. And then we will also do a repeat at 5:30 p.m. for people who find it a bit easier to get out in the evening. So we hope that you can join us for the executive breakfast to learn more about the TAWC program and how it can benefit you and your employees. Thanks very much.